Good morning, everybody. I'd like to welcome you back to our ongoing In the Trenches series dealing with regulatory crisis or regulatory concerns in the wake of the COVID-19 pandemic and the financial implications that have resulted from that. Today, once again, joined by my colleague, Craig Nazzaro, also a financial regulatory attorney on our financial regulatory team. And we've got an interesting topic to discuss today. We're talking about where the Bureau, the Consumer Financial Protection Bureau, CFPB, may be going in 2020 and 2021. Before we begin, just a brief comment about our methodology here, how we were thinking about this. And so what we've done is we've gone back historically and looked at the prior administration's rulemaking agendas back when Director Cordray was in charge of the CFPB, and then compared that to what's occurred during the last 3 or so years under the current administration and Interim Director Mulvaney as well as Director KRANINGER's leadership, and looking at how those two compare, because I think that may give us some indication of not only where the current rulemaking agenda is heading, but also in the event there is a change of administration, and particularly in light of one of the things we'll talk about, the recent determinations that the director of the CFPB can be removed by the president if there is a change in administration, where potentially those items were that were either left open in the 2016 period, and then also where there have been stated goals for rulemaking and where the Bureau may try to go forward into 2020 and 2021. When we talk just generally about where we're going today, we're really going to try to focus on letting you take away an understanding of what the current issues are, as well as what these upcoming events are that may drive changes at the Bureau. So what we're looking at is ways that there are current rulemaking, ways the pandemic is impacting consumer financial regulations, and how that may drive the agenda. We'll talk a little bit about in detail about what these changes may be going forward. And then finally, we're going to be talking about how you should be thinking about these changes as you're planning your regulatory and compliance cycles for 2020 and 2021. Really, there's kind of a perfect storm that's brewing, a series of changes that have occurred that are driving these shifts at the Bureau and generally within financial regulations. Obviously, the one that we've already mentioned at the start and that's at the top of everyone's mind is we're truly seeing the impact of COVID-19. As we talk about what regulatory priorities will be, how compliance will look in 2020 and 2021, we can't do so without being cognizant of the fact that likely defaults will begin increasing. You've already seen a huge increase in the number of mortgages and consumer installment loans or financial products that are in forbearance or in temporary suspension or having interest rates forgiven. Obviously, student lending with the federal programs has been generally suspended, no payments, no interest accrual. Mortgages, we continue to see that cycle, although it is somewhat coming down in the last few weeks, that are all driving how we think about regulation. And when we see these downturns in the economy, if we look back historically at past recessionary environments, what you see is a shift in regulatory focus, looking at default servicing, looking at forbearance programs, looking at fair lending and discrimination in terms of your loan modifications. All that's going to change the focus, we believe, of federal regulators as we go into this next economic cycle. As we see these defaults increase, as we see more complex technology-driven financial products that are coming about as a result of the COVID-19 pandemic, these non-face-to-face transactions, electronic disclosures, you're going to see regulations begin to try to catch up and respond to these changes that we're seeing within the macro economy or macro financial services economy. Layer on top of that, you may also have a change in administration in 2020. Obviously, without commenting at all on the administration or the results of the election, I think it's fair to say that in 2016 there was dramatic changes at certainly the top of the CFPB when you had Director Cordray leaving his 5-year term early, and being replaced with Mick Mulvaney as he took the helm at CFPB. And we'll talk a little bit about that in detail, but there was a significant shift at the top. Many, very smart people will debate whether or not there was actually a change in the mid-level, the career individuals at CFPB, or the frontline examinations teams or enforcement teams. And I think that is a fairly fair assessment. Working with different folks at the CFPB, even though there has been a shift at the top, a lot of the folks that we saw in the, when Cordray was administrator or director are the same folks that we see now. That being said, we'll talk a little bit about some of the structural changes that Director Mulvaney had made during his service, and how some of those may ultimately be unwound, and what impact that may have on how the Bureau approaches both supervision as well as rulemaking, and then in turn enforcement as well. There's also been a significant shift in the tone at the Bureau that we'll talk about, and whether that, if there is a change in administration, would then reverse back. And we'll talk a little bit about some of the public comments that have been made. But I think it's fair to say that all of us who follow the CFPB have seen that there have been significant efforts right now at the top levels of leadership at the Bureau to try to change their approach from a protection organization for consumers, a watchdog against industry, to what the current leadership of the Bureau asserts is a balanced approach that weighs all of those concerns equally. And then obviously innovation. We joke sometimes that the current pandemic has been altering how we view financial services products. And what has changed in the last 5 to 10 years will now be built on the COVID-19 pandemic, which has probably accelerated the adoption of financial technology by another 5 to 10 years. And so if you just think in mind exercise, you go back to the beginning of 2015. So before the last election, you think about what the most cutting edge financial products were at that time. You were beginning to see the rise in significant online lending. You were beginning to see non-bank payment systems beginning to become more mainstream. And then if you think about it now, every one of us may have 3, 4 payment apps on our mobile device. We're used to working through a non-face-to-face interface with our financial services providers. We're very comfortable with applying for loans online, being approved online, being funded remotely. Just this simple shift from 2015 to 2020 has been dramatic. And we expect that, just like the prudential financial services regulators, the CFPB, both in its role as a direct regulator of larger participants, as well as its rulemaking authority, will continue to dial in their regulations, their rulemaking, in order to adapt it to these changing technologies. We'll talk about a few of those already. There's already been efforts to provide guidance on artificial intelligence underwriting and machine learning being used within lending systems. There's already guidance that's come out regarding debt collection, having to adapt to new changes that have occurred. What happens when a debt collector sends you a social media message? How do you consent to that? What are the regulations around it? Things that simply, in 2010, we would never have thought of debt collectors, sending you a message on Facebook. We probably were not to the point where we had sophisticated underwriting that occurs almost instantaneously to approve consumer loans, and that are using, we've worked with some clients that have up to 20, 30,000 different data points in their underwriting engines. All of that leads to the new challenges when you're now applying, in essence, a series of 1960s and 1970s based statutes and regulations in kind of our core financial services statutes, and then applying them to these new technologies. So a lot of changes coming there, and it really is creating a perfect storm for a shift in the regulatory environment as we move out of 2020 into 2021.
We also want to cover start from the tone from the top. So we pulled 2 quotes here. One's from Richard Cordray, where he outlines what the mission of the Bureau is, to stand by the consumer, and kind of that single-minded focus of the Cordray or CFPB, where it was, we're here to stand with the consumer, and we protect them at all costs. Then we flipped that to the second quote there from Mick Mulvaney when he took over, saying that almost criticizing the previous approach, saying that the philosophy was to push the envelope aggressively, and then under the assumption that the CFPB were the good guys and the financial services industry were the bad guys. He went as far as to say the days of aggressively pushing the envelope are over. So you can kind of see the immediate flip in tone there. And then in the next couple slides, we want to kind of illustrate how that tone has driven some of the initiatives. So here are the enforcement trends. One of the things I say this often that I like about the CFPB is the amount of documentation that they provide. It really is insightful as you work through their website. This is from their enforcement section on their website, and they have a search function where you can search all the enforcement actions, categorize them. If you were to go through them through year by year, you can see our graph here that we populated. And it's important takeaways here are in 2012, the Bureau was just coming on the scene. They came on the scene in 2011 and started with mortgage, and then they consistently took on more oversight as they aged. So the enforcement actions that you're seeing in 2012 aren't necessarily reflective of the total population of their oversight. You know, they started adding more lines of business, more consumer products to their oversight as they aged. So as they got into 2003, 2014, you see it consistently going up. 2015, they hit their peak of 54 actions. 2016 is the election. They dropped down to 42. It's still a large amount of enforcement actions. 35 in 2017. Cordray was still there. Cordray stepped down in late 2017. His 5-year term would have been ending in July of 2018 anyway. We're going to talk about how that term works in a few slides. But then you see, as soon as Mulvaney took over, there was 11. Then there was 25 in 19, and back down to 12 in 2020. Actually, last night they announced one more fair lending action, so that 2020 number is now up to 13. Next slide, Brad. This is also illustrative of how the tone from the top drives the priorities or the scope of what the Bureau is doing. So if you were to look at how the CFPB is how they receive their money, the director of the CFPB, the current director, requests the funds from the Board of Governors, the FRB, and just has the funds transferred from the FRB into the CFPB's accounts. And that's a majority of their operating budget. As you can see here in 2000, and also again, speaking to the CFPB's documentation processes, on their website, you can review their budgets and their strategic plans year over year. Again, very insightful to see what they're focused on, what they're looking to allocate more funds to, and can inform your risk and compliance functions internally at your institution. What we want to point out here is in 2017, again, you see a high of $600 million taken from the Federal Reserve or requested from the Federal Reserve. That was Cordray's last year again. He stepped down in late 2017. The first year Mulvaney took over, you see a drop of more than $200 million in funds requested from the FRB. Now that's not the entire operating budget, but it's a significant portion of it. And it's very interesting to see how that one change at the director level can literally dictate the scope and the ability of the Bureau. Also wanted to point out that the fiscal year 20 budget overview, the current director actually states that litigation should be dying down, which is interesting to see. I think the second bullet point there, litigation costs are expected to decrease as the Bureau resolves significant numbers of outstanding enforcement actions in 19. And it is just very telling as to what the current leadership of the CFPB sees as their priorities going into 21. Next slide, Brad. I'll give this one back over to you.
And so then as we look at the enforcement action velocity, and it kind of plays off of what Craig was just mentioning, you've seen a shift in total civil monetary penalties that have been collected. Obviously, as Craig mentioned earlier, with the Bureau coming back, coming into kind of its own in 2012, you obviously have a very, very low number there as it began, building its infrastructure. But then towards the end of 2017, 2018, you saw these 2015, 2016, the last 2 years, full years at least, of Director Cordray's tenure. You saw a pretty dramatic increase in the civil monetary penalties that were assessed. Then you see a drop off into 2017 as you start to have the change of administration, change of leadership at the CFPB. 2018 is somewhat skewed. 500 million of that is the Wells Fargo settlement. The other is 22 million with all other parties who were part of the civil monetary penalties in 2018. So, take that as you will, but, it's about $22 million in non-Wells Fargo money, 500 million in the Wells Fargo CMP, that also had a $500 million penalty to the OCC associated with it. Then again in 2019, 131, and through 2020, which is obviously tailing, but the second quarter report that the Bureau issued, they have collected 2.68 million so far in civil monetary penalties. So what you see is a lot of the shift in enforcement. The civil monetary penalties that are being sought are, one, likely being driven by somewhat the financial services that are underlying this and what the underlying concerns are, but you also see that there being some shift as the leadership of the CFPB changes. And certainly in 2020, the CFPB has had its hands full, obviously, dealing with the fallout from COVID-19. So part of that may be explained by delays within the judicial system, et cetera. But nonetheless, 2.68 million through the first two quarters. So it'll be really interesting to see where 2020 ends up. The takeaway from this is, as you're thinking about your compliance structure as you move into 2021, if you look back at the other prudential regulators pre-Bureau and you look at where their enforcement actions lie, following the wake of the recession, the last financial crisis, you saw a big increase in the number of prosecutions, number of the amount of civil litigation, and then the settlements that came about in the wake of that financial crisis. And so when we look back at that for guidance, we would expect to see, as defaults increase, as more complex servicing, default management, and consumer financial relief become important through Q2, Q3, Q4 of 2020. And then potentially, as we said, that perfect storm where you potentially have a change in administration, you may see a big uptick again in the enforcement actions and the CMPs, the civil monetary penalties, that are being sought by the Bureau. And, kind of tagging on to that, the House Financial Services Committee, Representative Waters' committee in the House published a report in late 2019, I believe it was October of 2019, that actually looked at this from their perspective, and one of their criticisms of the CFPB was a dramatic decline in the enforcement activity at the Bureau. And so you see here some of the data slides that were presented within that House report that's available. The title of it is there on the top of the slide if you're interested in reviewing it, that was comparing Director Cordray's tenure with Director KRANINGER's tenure once she took over leadership of the CFPB, and looking at the relief that had been obtained for consumers comparatively in those two time periods, as well as the raw number for enforcement actions that the Bureau was bringing. And so, as you look at that, you can see that if there is going to be a change in administration, this may serve as, again, an indicator of where the new administration will be looking to take the CFPB. And so I think if that occurs, we would expect a fairly dramatic increase in the number of enforcement actions that are filed, as well as the demands for civil monetary relief at the Bureau. And that may occur naturally, even if there is not a change in administration, as a result of the much more complex servicing obligations and consumer relation issues that are coming about as a result of the COVID-19 pandemic. Craig,
thanks, Brad. The next item we want to focus on here was the current focus of the CFPB and what's driving their supervision and enforcement. These are some comments from the Financial Stability Oversight Council meeting that the director gave in mid-May. First, I want to point out that she points to the consumer complaint system of the CFPB, that it saw record volumes in March and April. We'll go a little bit further into that in a couple more slides. And also, kind of just indicates basically that business as usual in the customer complaint space for the CFPB. It's driving their focus. It's informing their supervision activity and their enforcement activity. But what was very interesting about these comments were that it also spoke to the pandemic and what they're seeing within the pandemic and how they're going to kind of adjust their risk-based focus to pandemic-related issues. In that third bullet point there, we see the prioritized assessments. We've seen a few of these be sent out. We haven't seen them work through yet, but we know that they're focusing on both markets and institutions that pose the greatest risk of consumer harm as a result of the pandemic-related issues. I take that to mean that they're going to focus on more default functions, debt collection, credit reporting, any lines of business that they believe will be impacted greatly through the shift in the economy due to the pandemic. Next slide.
Yeah, and really good point there, Craig, too, is, as we think about, potentially, lenders or other participants in the financial services sector getting these prioritized assessments. Anyone who has a large exposure in mortgage, has large consumer portfolios, student loan servicing, all of those industries that specifically have provisions impacting them vis-a-vis the CARES Act and some of the other COVID response programs passed through the legislature, those are likely some of the early targets for these prioritized assessments. And so if you do, participate in those, regulated industries that are being impacted by COVID, be prepared that particularly if you have a less than stellar track record in the past, you may be called upon through these prioritized assessments in order to specifically respond to Bureau inquiries relating to your consumer compliance programs.
And to Brad's point earlier, I don't want to conflate the issues of a change in administration with, day-to-day operations of the CFPB. We represent a lot of clients and that are going through supervision or assist with supervision practices. And you're still seeing, no matter which administration is currently in office, you'll still see the EICs and the attorneys in the CFPB focused on the consumer lending laws and applying them correctly. I don't want to get the idea across that just because the enforcement action or activity decreases with the change in administration, that's like on the peripheral of the application of the consumer lending laws. If you're playing in a gray area or you're pushing the boundaries a little bit, you start to see a heavy hand in penalties and greater enforcement activity for same thing in fair lending violations. But for like complaint-driven issues, no matter who wins in November, you're going to see the supervision activity driven by complaints and that complaint database in the CFPB. That's been a constant since the CFPB's been on the scene in 2011.
Now, one thing I would note before we go to the next slide, Craig, we do have a question portal. If anybody does have questions that pop up during the presentation today, feel free to shoot those in, and we'll try to respond to them if we can in real time as we're going through this. If not, feel free to email us. But I did want to make you aware that there is a question portal within the webinar app here that you can feel free to send those in if you do have questions that come up as we work through this.
So this slide, we wanted to highlight, we've used portions of this complaint bulletin from May of this year in other presentations, but we pulled different data points out for this one. The hyperlink when you get the deck is worth clicking through. If you haven't read this particular complaint report, it should be driving some of your risk compliance functions currently. Goes to point out that the CFPB points out in March and April of 2020, the Bureau's consumer response teams received a little over 36,000 and 42,000 complaints, respectively. That's the highest monthly complaint volume in the CFPB's history. The next 4 bullet points, we pulled what they're seeing in those complaints. So the first one there, unable to reach customer service representatives to talk, consumers reporting hold times of several hours to get through. For consumers that are pursuing payment options, some describe no methods other than phone access to potential clients. Then the Bureau went on to say that they're seeing these issues arise in mortgage, credit card, auto loans, lease, student loans, and personal loan lines of business. So to me, if you're in those lines of business, this should be on your monitoring and testing. You should be looking at your call hold times. You should be looking at your other channels, your alternative channels besides phone for customer service and for these issues, and kind of tracking your call time and putting that in your board reports. If the Bureau is putting in a complaint report, it's going to be on the EIC's agenda to look for in your institution. And that's regardless if you're doing well in those areas or not. They're going to be looking, so you should just look ahead of them and try to remediate any issues that you find. Next bullet point there, they raise that consumers who are pursuing alternative payment options express concerns about the potential negative credit reporting implications, that consumers are concerned about negative reporting and consequently reduced ability to obtain financing. Again, if you check your credit reporting, your FCRA compliance, this should be raised up as you're switching to a default environment. As more and more consumer loans default, the focus is going to be on FDCPA, FCRA, and how you're complying with those. And not that they weren't on those, but they're still in the modules, in the performing environments. But now that you're seeing more defaults, you're going to see a shift to, greater focus on those areas. Next up, you see debt collection. Consumers reporting dismay that the companies are continuing collection activities during a national emergency. You know that the Bureau is going to come in there and say, all right, you were under lockdown or you were, stay-at-home orders. What were your debt collection policies looking like at that point? Did you adjust your procedures in any way to kind of limit the consumer risk and the consumer anxiety there? You want to look at those issues. And finally, they point out that the lump sum payments due at the completion of forbearance periods. This was a big problem in 2010, 2011 too. None of the regulators, the CFPB, the OCC, the Fed, or the state AGs for that matter, all took issue with putting people into forbearance, not kind of looking at how they were going to exit that forbearance. They looked at it as just almost as abusive to put somebody in a forbearance plan that they would not be able to exit as not putting them in the forbearance plan at all. So you kind of want to look at those. Typically, it's seen in mortgage. The CFPB pointed that out there as well. But look at the disclosures that's around that forbearance plan. Look at your procedures of how you're underwriting those or approving those. Are you approving them blindly? Are you looking at them with some kind of thought to the ability to repay of the borrower? And are you documenting that? So if it does become an issue, the regulator can come in there and see that you were thinking about it and just, maybe pick a different path than they would have, but that it was contemplated and part of your risk analysis.
And I think, Craig, there you make a great point, which we covered pretty heavily in the previous presentation on preparing for your first post-COVID exam. But make sure that your compliance programs, your oversight, your monitoring, your testing is being responsive to changes. So if you were a student loan servicer and you're impacted by either the state or the federal restrictions, make sure you are updating your compliance management system to address those changes. If you have a large mortgage portfolio, similarly, making sure it's taking into account these changes and having those documented policies or procedures so that if the Bureau does question those, you have them available to demonstrate. In essence, you have to have a responsive, adaptive compliance program that's going to react to what's occurring around you.
Next up, we want to address the SCOTUS decision from last week. I found this entertaining to follow for the last couple of years, starting with the PHH case and now the CEDAW law. For those of you who haven't been following closely or didn't pay attention last week when this came out, the law firm was one that provided debt relief services to consumers. They were under investigation for the CFPB for TCPA violations. Just like PHH, they challenged the CFPB's authority to request documents from the firm, arguing that the Bureau's structure was unconstitutional because it had just one director, and that director was only removable for cause. If you haven't been looking at this issue since it was raised when the CFPB was being put into existence, when the CFPB was built and Dodd-Frank was being drafted, the Democrats controlled both houses as well as, Obama was in office. So they were able to build it out with substantial protection and make the Bureau as independent as possible. It was debated whether or not that should be a commission that led the Bureau or if it should be a single director. And if a single director, should it be removable for cause only. And that's the way they went, thinking that, look, the CFPB is not going to be popular, so let's when the change in administration occurs, so let's kind of put as much protection for that independence as possible. It was immediately attacked by the Republicans at the time, and then kind of you saw the lawsuits come. The PHH suit was first, and then this lawsuit was second. This is the first one that made it up to the Supreme Court, and last week a divided Supreme Court ruled that the restrictions on the removal of the CFPB director were in fact unconstitutional, as they violated the Constitutional Separation of Powers Clause. They did, however, refuse a broader challenge by the law firm seeking to invalidate the CFPB totally, saying that just because the director is unconstitutional, the provision protecting the director was unconstitutional. So down there we have the justices that, it was a 5-4 split decision. The justices that ruled that it was unconstitutional are all party aligned with the Republicans. The 4 that dissented were aligned with the Democratic leaders. I find it interesting because, like, some of the headlines that came out that day was Supreme Court mandates Joe Biden fire the CFPB director January 20th. And it is what you will see play out, and you will see this play out again and again and again until the structure of the CFPB is put up in a way that's nonpartisan. And this kind of also lends itself to what kind of swing we would see if there is a change in administration. As we just went through the tone from the top and how it's driving enforcement activity and collection activity, giving the ability to fire that director now at the pleasure of the president kind of loads the gun for a change in administration. If it switches parties, you could see the CFPB constantly going back and forth between their mission and how they're driving the Bureau's supervision and enforcement activity. Next slide, Brent. Back to you.
Yeah, and here's this, if you came for the slides, here's the one you're probably most interested in. The next 2 slides, what we did is we dissected the pre-shift in administration rulemaking agenda, and then compared it to what actually has or has not been implemented under the current administration. So if you were looking and said, if there is a shift in administration or what is still hanging out there from Director Cordray's tenure that has not been fully implemented at this point, where potentially could that agenda shift to in 2020, 2021? Or similarly, if there is no change in administration, what are some of the hanging rulemaking issues that are still floating out there? So what this is, these next 2 slides, it dissects those old agendas, and we're going to go into a lot of these in detail. But, as you go through, one of the important things is that, in fact, frankly, I was somewhat surprised, is there was not a lot in the 2015 and 2016 rulemaking agendas that had not had some action on it during the change in administration. And now, what we did see, and we'll go into this in detail, is there was a shift in the scope of the regulations. There are a few that are just, kind of black and white. For instance, the arbitration agreement proposal that would ban arbitration agreements and consumer financial services agreements. That was simply overruled through the Congressional Review Act, where Congress acted, and then that CRA resolution was ultimately signed by the president. And so the ban on arbitration agreements has fully come off the table until legislative action is then advanced that would overturn that prior Congressional Review Act determination. But then if you look at others, it's all somewhat nuanced, such as we'll talk about the payday auto title and small dollar loan rules. Certain portions of it were carried through, particularly like the payment provisions and provisions dealing with how you charge consumer accounts. However, the ability to repay rule section of that regulation or that rulemaking was stripped in the rules that came out about a week ago now. Similarly, like for instance with overdraft protection, there are a few changes that have been made over the years, but there's still no full implementation of some of the articulated agenda. We'll talk about that. There is some proposed rulemaking, in case you're wondering how quickly federal rulemaking works. Such as the debt collection restrictions. It was on the 2014, 15, and 16 CFPB agendas. That rulemaking, the notice of proposed rulemaking, finally issued in May of 2019. There again, it was stripped down from what was originally proposed while Director Cordray was leading the Bureau. But nonetheless, there was a series of rules that came out in early 2019. We'll talk about prepaid rules. There's a few too, like we say, no expansion yet on the larger participant rules. There was proposals to bring in kind of the quote missing areas within CFPB oversight, that being consumer installment loans that were not payday loans, as well as vehicle title loans. Payday lenders are subject to larger participant rule and direct oversight. Title lenders are not and have not been brought in yet. Same thing with installment loans. Credit cards, student loans, all of those are in. It just kind of what I would call vanilla consumer installment lending is not yet brought into the larger participant rule. And so rather than go through all these, I think it probably makes sense for us to dive right in and start talking about some of these. And, with that, we'll specifically start out here with the payday lending rule. And so, Craig, I'll turn it back over to you.
Thanks. So this month, the CFPB announced the final rule covering small dollar lending, which rescinds the mandatory underwriting provisions that Brad was touching on that were found in the 2017 payday lending rule. As we were saying, you can kind of follow this. All of these rule promulgations and guidance kind of started many years ago, and you can start to see the initiatives build. So this actually started with a white paper in April of 2013 and kind of moved into advanced notice rulemaking and the final rule in 2017. Then in 2019, we saw an updated rule announced saying we're going to delay the implementation of that 2017 payday lending rule. So it was very much considered, okay, we're going to see the more conservative sections of this rule be rolled back. So the findings in the 2013 white paper and the overall drivers for the payday lending rule were twofold. The first one was balloon payments, short-term and longer-term loans were viewed as unfair and abusive practices for a lender to make by the Bureau. Therefore, we saw in the 2017 payday lending rule that it required, before making such a loan, a lender must reasonably determine that the consumer has the ability to repay the loan, creating a mandatory underwriting provision. And second, for the same set of loans and for longer-term loans with an annual percentage rate greater than 36%, that they are repaid directly from the consumer's account. The 2017 payday lending rule stated it would be unfair and abusive to attempt to withdraw that payment from a consumer's account multiple times. After 2 consecutive times, you would no longer be allowed to make an attempt. Next slide, Brian. So then this month we saw a rollback of 4 major points within the payday lending rule. Basically made it more payday lender friendly. The mandatory ability to repay analysis was removed. The mandatory underwriting requirements removed. ATR ability to repay exemptions were removed because they're no longer needed. And ATR implementation provisions were removed, which established definitions, reporting requirements, and record-keeping requirements. These were going to be an extreme burden on the industry. They were all rolled back just with this new rule that came out this month. And this is kind of, as we're going through this is a good illustration of the problem here. So I view it almost as more detrimental than actually having to deal with that rule would be having that rule implemented, building a program or controls or contemplating that, or adjusting your internal controls and compliance departments and risk departments, and then having it rolled back. If they constantly swing back and forth like that, the burden on the financial industry is way more than just the overregulation in the first place. It's very difficult to, get the subject matter expertise within your institution itself to monitor the constant change in multiple business lines, as well as staff up and staff down accordingly with the requirements that are being put forth, contemplated, and then rolled back within a couple of years. Next slide, Brian.
Yeah, and the arbitration rule is a really interesting history. It's one of the first times that well, it's actually, I guess, technically the second time the CRA, the Congressional Review Act, had been implemented. And so what the Congressional Review Act was it was a mechanism that allowed when an agency issues rulemaking, Congress starts a clock, and they have 60 congressional days, meaning days in which Congress was in session, in which to review it, and using a simple majority, Congress can overturn rulemaking. It's got to be approved by the president. Once that CRA, that Congressional Review Act resolution, has been passed. And interestingly, the net effect of that is it will prohibit that agency from issuing rulemaking on that same topic with that same rule until such time as the legislature goes back and overturns that CRA resolution. And so what we saw here is the Bureau issued a series of public inquiries, ultimately issued a rule that said you could not have mandatory or contractual arbitration provisions inside of financial services contracts. Once the administration shifted and the House and Senate became Republican, they both passed it by majority within that 60-day period and effectively kill off the arbitration rule. And so presumably then the Bureau would not have the ability to reinstitute a prohibition on mandatory arbitration absent legislative action. And I say that kind of generally because there's all sorts of questions about the scope of the CRA and what counts as actually violating the CRA. But nonetheless, there is the presumption is the Bureau could not then issue a arbitration prohibition rule until such time as that action was taken. Interestingly, the other issue that the House and Senate took up through those CRA authorizations, I just throw it out there as kind of an interesting aside because it's created quite the conundrum for auto lenders, which is there was guidance documents, not even formal rulemaking, that the Bureau had issued regarding discrimination in auto lending rate markups, or what we call rate spread premiums. And what it did is there was a series of guidance documents that the Bureau had issued that talked about when it was permitted to do markups, where the dealer could take a financing package, add additional interest rate to it, and then sell that to the consumer. And there were certain restrictions on how that was going to work. You had certain fair lending issues that were arising as a result of that because data indicated that oftentimes that created a disparate impact on borrowers. And so the Bureau issued a series of guidance documents that placed limits on how that markup was going to occur. And interestingly, there was a opinion in the Senate that this was subject to the CRA. A CRA resolution was passed, and that too was stripped out. And Director Mulvaney at that time then issued a notice revoking that prior guidance. Interestingly, the other kind of odd conundrum of this is the actual guidance document itself came out under the new administration. So there's this whole question about, if the purpose of the CRA is to unwind what they call midnight rulemaking of a prior administration, in this case, technically that guidance came out under the new administration, and could Congress then go back and unwind it? And so far it has been enforced. Where the conundrum occurs is, as a practical matter, all compliance attorneys as well as compliance professionals generally look to that guidance when they look at issues relating to auto lending rate markups and fair lending concerns within an auto lending portfolio. Huge question about how it is enforced, whether it could be enforced, but most of us in the compliance space look to it still as guidance for how you can think about it, because it really was just a guidance document and substantively changed the rules within Reg B and the Equal Credit Opportunity Act.
So another major topic we want to touch upon here is fair lending activity and how that's changed, or even what the structure of the fair lending department within the CFPB has, how that's changed as well. The first thing we want to point out here, in late November 2017, one of the first things Mick Mulvaney did when he took over from Cordray was that he moved the Office of Fair Lending out of CEFL, which is Supervision Enforcement Fair Lending Department, into the Director's Office directly. This effectively sidelined Patrice Flicklin by stripping the office of the enforcement powers. It was message that wasn't the intention, and that's not what was occurring. But we're going to go through the numbers in a little bit just to see kind of what happened there. But we also highlighted here during the October 2019 House Financial Services Committee meeting, we had Congresswoman Joyce Beatty asked Director KRANINGER, why has the CFPB not issued any fair lending violations in a 6-month period, citing the fair lending report from the CFPB. She went on to state that this is the first time in history that there was no discrimination in 6 months. Do you really expect me to believe that? director responded that it's not a measure of discrimination. The report itself is not a measure of the discrimination that's occurring or happening within the institutions we're overseeing. So the congresswoman quickly replied, so there was discrimination, we just didn't do anything with, we just didn't deal with it. This kind of illustrates also the kind of tone that you can see if you're expecting a change in administration. If you go back and read the transcripts from these House Financial Services Committee meetings, you see where everybody's focus is. You'll see them ask about the rules that we're talking about here. They asked directly about the payday lending rule. They asked about arbitration rule. We're going to talk about debt collection in a minute. They asked about that. And you can see where the elected representatives, where their focus is. And it's pretty much split on party lines, but you can see what they expect the Bureau to do, and then, you know, the results of the questioning. And this occurs semi-annually. It occurs in October and then at the end of spring once more. Next slide, Brad. So here is the volume of CFPB referrals over to the DOJ. So again, when you're looking at this, 2011, the CFPB just came onto the scene, didn't have a lot of oversight of multiple lines of business. 2012, they had mortgage, started to bring on card and other lines of business. You start to see the office get a seat, and the activity that they were looking at in supervision in 11 and 12 start to result in enforcement actions in 13. Peaks at 14 with 15 actions. You still see 8 and 8 for 15 and 16. Change in administration occurs, 2 for 17. And then, really surprisingly, once Mulvaney comes in and moves that Director of Fair Lending position outside of CEPL, you see 0 in 2018 and only 3 in 2019. So in the last 2 years, the last 2 years, you've only seen 3 referrals from the CFPB over to the DOJ, which is surprising. And actually, one of them that we talked about earlier on the enforcement slides, that fair lending case was announced yesterday through the CFPB enforcement. If you want to take a look, it's a good read. Next slide, Brian. And here, I don't want to make it sound like it's just the CFPB. The DOJ as well has been clearing out their open fair lending cases. So it's kind of a mixture of the administration who's running the DOJ at the time, as well as the economic environment. They're intertwined here. If you look at the peaks, they come right after like a high default environment when you see, you know, people, how come basically banks tighten up their credit underwriting standards, people can't get loans, fair lending violations and complaints rise. So you saw that in 2010, then you start to see it work its way out of the system as the economy improved. You see a little bump there in 14 and 15, then it starts to go down again with a minimum of 7 cases now in 2018. Again, with COVID driving a lot of defaults, I totally expect to see another rise with DOJ cases and a backlog start to create. You're supposed to see more referrals from the CFPB as well as the other regulators. And that's why we say it's a perfect storm. So if you have that economic shift as well as a change in administration, it's like supercharging the issues. And that's exactly what occurred in 2009, 2010. You see what happened from 16 to 60 in 1 year. Next slide, Brad. This is the indirect auto lending issues that Brad was talking about. So in 2013, that's the guidance that we were touching upon earlier. That hyperlink there is the guidance itself. Talks about how ECOA is applicable in the indirect auto spaces. That was considered to be a best practice. We saw multiple enforcement actions come out, I think, like within a week of that guidance coming out, and they used those enforcement actions to illustrate what best practice should be and what you know, you should expect when you're being reviewed in the indirect auto spaces. In May of 2018, President Trump then signed a joint resolution disapproving the bulletin. And that, as Brad was saying before, it rolled back the guidance. It didn't roll back any of the actual oversight or application of ECOA within the indirect auto spaces. So we haven't seen any enforcement activity post the rollback of that guidance, but you know, we can tell you just from being in on multiple visits from the CFPB, they're still very much focused in the indirect auto spaces. You'll get the questions, you'll get you know, the questions around your monitoring, testing, your training programs with indirect lenders, and how you're applying your fair lending controls in that space. So the rollback of the guidance really didn't accomplish much, but throw more ambiguity into the space. It made it, you have practitioners lines of business thinking that, oh, hey, I read that there's no issues in indirect auto anymore. Part of our job is then, walking them through, well, now that as your peers are still seeing it, you will be seeing it. The guidance was rolled back, not the actual consumer lending protection. Next slide, Brad. One more thing we want to touch on here is women and minority-owned and small business reporting requirements. In Dodd-Frank, you have Section 1071, which required the Bureau to prescribe rules around financial institutions to collect, report, and make public certain information concerning credit applications made by women-owned and minority-owned small businesses. It's been on the radar for the CFPB since inception. It's literally in Dodd-Frank, the regulation. In May 2017, you saw the CFPB issue an RFI regarding small business lending and kind of get their footing in the space. They were used to consumer lending. They didn't want to get more depth in the commercial spaces. Then you saw it scale back a little bit once the director changed. Cordray stepped down. Mulvaney came in. You really didn't hear much about it. Then in November 2019, it came back. They hosted a symposium on small business data collection, kind of see what the industry concerns were. We know it's coming. We just don't know what form it'll take. This is something else that's going to be dictated by the administration. How conservative it's written or how hard it is to comply with could be driven by the leadership of the CFPB at the time. I will say that the PPP loan program is kind of supercharging this effort. You're starting to see the CFPB and other regulators state that ECOA has an impact on small business lending. It has an impact to the CARES Act lending, specifically the PPP program. So the CFPB is almost getting like a test case with how they're going to look at that data and kind of parse that data. They'll have it all in-house and begin to look at it in the next exam cycle.
Yeah, and to that point, I mean, when we look at all the data that was released a couple weeks ago on the borrowers under the PPP program, this is actually the classifications that they're using, although they did add veteran-owned businesses as well to the classification. But it's looking at are they women-owned businesses, minority-owned businesses, veteran-owned businesses, as well as the size of the business and the number of jobs. And so, yeah, if you're looking for what the premonition is, we now have one of those massive public data sets that's specifically looking at these issues within small business lending programs.
We also want to touch upon mortgage servicing here. So there's a lot of type for the slide, but you can go through the deck later. But the point here is starting a couple of years ago, as the Basel III risk rating was starting to be applied, you saw a lot of MSRs, mortgage servicing rights, migrate from depositories over to non-bank lenders and non-bank servicers. You then saw the Financial Stability Oversight Council, as well as the CFPB, and the GAO as well, start to focus on the risk that was creating. Once you move those MSRs outside of depositories, you start to lose the liquidity and the capital requirements surrounded by them. And you have a good majority of the residential mortgage market being serviced by non-bank lenders. You kind of saw this play out with the pandemic. As defaults started to rise, this is the first time we've ever seen that new defaults, a rising default environment with a majority of the U.S.'s resi mortgages sitting in non-bank servicers. You start to see issues then with, how these services going to stay solvent if, they have to abide by the GSE's the default rules. You saw a relaxation of those and rolled back. This was totally on the radar of all the regulators. The CFPB in 2016 supervisory highlights spent a full 21 pages expressing their concern about the range of legal violations identified with various non-bank mortgage servicers, that they were not seeing the remediation and improvement efforts that they were seeing in depositories in the non-bank entities as well. And that's driven by two things. Number one, they don't need a larger participant rule within mortgage servicing. They have the ability to go into any mortgage servicer out there and supervise them. The problem is there's so many of them that they can't get out there and see them all. Not like they can the depositories. Depositories, they're in there, on a schedule. So there's non-bank servicers, smaller ones that the CFPB never sees. it's creating like kind of a black hole of mortgage servicing. I do think that, coming out of COVID, you'll start to see a refocus on this, specifically because eventually it get picked up that, the regulators saw this and didn't do anything about it. And part of that was the timing as well. You started to see a build-up. 2014, 2016, you saw the greater focus, and they were zoning in on what the issues were, and then the change in leadership at CFPB occurred, and you really didn't hear anything again in this space. I believe that you're going to start to see this space, non-bank mortgage servicing, heat up again in the next 6 to 12 months, regardless of who wins the election in November. I think it's going to be an area of focus. I think the next slide's back to you, Brad.
Yeah, and so when we talk about what's left in 2020, before we get to kind of finally our crystal ball predictions here, let's talk a little bit about what's still left on the 2020 agenda that we're expecting. We still have PACE financing, which is a property assessed clean energy. This allowed consumers to obtain energy efficiency products for their homes, solar panels, energy efficient HVAC equipment, and then finance it through tax assessments, meaning you would cooperate with your utility provider, and your utility provider would actually offer these programs, and you would in essence pay for it over time. And the thought was that the energy efficiency savings would outrun the additional expenses that were being put onto your utility bill or through your taxing authority. And so in March 2019, we've had a notice of advanced rulemaking for the implementation of that PACE financing infrastructure. It's actually a series of amendments to Reg Z. Interesting, a few things if you are playing in PACE financing is it will have ATR requirements that are similar to home mortgages. And if you're listening, as we talked about the payday rule, obviously ATR is one of those highly contested issues, and how you actually conduct ATR and the level of ability to repay analysis. But just understand that in essence, PACE financing will be coming in similar to home mortgages with fairly robust ability to repay requirements implemented as part of it. Really interesting. We've been expecting this one for a long time. This actually dates back as we were reviewing the old rulemaking agendas to 2012, 2013, which was updates to debt collection rules. Again, as you look at this, just understand that there was a very robust set of regulations that were previously advanced and supported by consumer advocacy groups. The current rulemaking walks a number of those back while also imposing a series of restrictions. If we look at, for instance, some of the commentary the consumer advocacy groups have come out with, we'll talk briefly about that. It really is kind of drawing a little bit of a line seeking to have more oversight of the debt collection industry, but perhaps most meaningfully, there's going to be significant restrictions on how often you can call a consumer, how long you have to wait after speaking to a consumer, trying to make it easier for a consumer to understand debt collection notices and ways for the consumer to dispute the debt, and then also generally restrictions on the industry. Like we talked about earlier, there are some pretty interesting changes regarding consent to use email, voicemail, text messaging, and interestingly, social media contacts in order to pursue debt collections. And so the idea is they're trying to put some teeth into the FDCPA. We'll talk a little bit about some of the teeth that were removed from this rulemaking that may be part of a 2021 agenda. Small change that came out late 2020 was an escrow rule exemption cleanup. There were concerns that there was a smaller participant rule. Anyone with less than $2 billion in assets and a smaller loan portfolio that was offering higher priced mortgage loans. Remember, those are those loans where the APR exceeds the APOR, average prime offered rate. And it gave an exemption for smaller servicers who had less than $2 billion in assets. Part of that legislation on the Economic Growth Act was to raise that to $10 billion. That's been now implemented. Perhaps one of the most interesting things the Bureau has been doing recently that we've obviously been working with our clients on is with the shift away from LIBOR that's going to end potentially in late 2021, although there are some talks about continuing it because the Bank of England is having concerns over it. This creates a fairly clear set of guidances regarding how you would go about notifying consumers of that change, how you shift to alternative indices, Perhaps the most important thing to take away as you're planning for late 2021, 2020 is you need to be looking at these alternative rate indices, looking at how you're going to run your notification program, because while there are some model language that the Bureau was promulgating here, it is going to require change in terms notices, the ability to clearly communicate this out to consumers. So you need to be planning ahead, not only for the economic risks associated with that shift, but also for how you're going to do consumer notification programs, as well as making sure that your alternative indices meet these requirements. Interestingly, the Bureau has done a little bit of a safe harbor where you could shift to Wall Street Journal Prime as your alternative index, or as the ARC finishes up their recommendations on what the quote spread is between SOFR, the new Fed Reserve rate, and LIBOR, you could also use that alternative rate and safe harbor. Really cool issue came up last week that I think is kind of a sign of things to come. Bureau, July 7th, issued some underwriting or some guidance on underwriting using artificial intelligence. More and more, we're seeing lenders, like I say, who may have 20, 30,000 data points they're collecting, particularly with screen scraping technology where you can pull a consumer's bank account out. There's more and more of this occurring, and the Bureau really kind of did two things, which is one, re-emphasize that there is still obligations under ECOA and the Fair Credit Reporting Act. You still have to send adverse action notices, but some really interesting clarifications there, which is when you send those adverse action notices, you don't have to explain how a factor impacted a score or decision. You just have to accurately describe the factors that were considered. So if, for instance, a lender says, if you engaged in online gambling transactions, we will not make you a loan. Then you can disclose that in your adverse action. So if you had online gambling transactions, you don't have to explain the impact, why it matters. You do obviously have potential fair lending issues there. Nonetheless, the adverse action notice is simply to describe how that impact, or you don't have to describe how it impacted, just that it did. Same thing, Bureau is really looking at this as potential expansion areas, and I think you can look at that in context of the no action letter that Upstart got back in late September 2017. The Bureau issued a no action letter to Upstart, allowing them to look at a more broad spectrum of underwriting criteria when credit score was, quote, not enough. So it would actually look at your degree of education completed, whether you were in a degree program, and did you have a job or verifiable source of income. And, August 6, 2019, in that context, Bureau comes out with an update. Bureau, if you read the tone of it, is very pleased with how that program worked because they compared it and said, by using these alternative scoring methods, instead of just credit scores, 27% more applicants were able to be approved for loans, and there was a 16% lower average APR for those loans that were approved. And so it's still this concept that you could use this as second look underwriting. Still a question whether you could use this primarily underwriting because of the fair lending issues associated with it. But the Bureau is clearly trying to encourage that type of innovation within the financial services sector. And kind of along those lines, we also have the trial disclosure sandbox that's come out. So we obviously have this no action letter program where you can write in, ask the Bureau to state that some action you're going to take or position you're going to take is not objectionable to the Bureau. You also, if you have a better way of doing disclosures, or you potentially have a more innovative financial product where the disclosure obligations are not clear, you can actually apply into their sandbox program, put forward your trial disclosure, and they have the ability to give you immunity from CFPB claims under Reg E, the EFTA, Equal Credit Opportunity Act, Reg B, as well as the Truth in Lending Act, Reg Z. And so that's extremely valuable. And interestingly, kind of going back to this question of carryover between administrations, is generally that provision is granted for 2 years, and there's immunity during that period, and you cannot revoke that determination. You can terminate it, but once you get that determination and that immunity, you cannot later be prosecuted because of different interpretation of the regs. So a really interesting process there for innovative financial services providers. Also, Director KRANINGER has indicated that she is concerned that they are one of the largest prudential financial regulators that do not have a process for issuing interpretive letters or advisory opinions. And there are very few times I'll opine on something, but she's right. It would be just tremendous if the Bureau would issue interpretive letters and advisory opinions. And so she has expressed an interest in coming up with a process for the Bureau to move forward with those types of programs. And last, as we kind of close out here, we'll talk a little bit about the crystal ball. What are we looking at as we look into 2021, 2022? If there's a change in administration, we think there will be a shift back towards enforcement. It'll probably be moved back to a standalone entity outside of the director's office or back with fair lending. And there's probably going to be a push to make more public enforcement actions, less confidential supervision of direct supervised entities, really a push for public enforcement. Student lending has been kind of conspicuously untouched in the last decade. And so there are rumblings that there will be updates to either the student loan disclosures that have not really followed some of the updates you saw on the mortgage side of the shop, as well as there are ongoing concerns about unfair, deceptive, and abusive acts and practices being engaged in by student loan servicers. So we expect that that may come up as well, particularly given the complexity now of student financial services products with the federal income-driven repayment options, what have you. There are a lot of complexities inside of student lending right now, and candidly, a lot of those disclosures have not tended to keep up with the complexity in student lending. Debt collection, these were the pieces that consumer advocates had pushed for that were portions of the original rulemaking. If there was a change in tone, these are things that potentially could come back in, which is in essence putting additional restrictions on debt collectors, and trying to avoid some of the abuses in the debt collection industry. Similarly, obviously there's always a focus on fair lending. We've heard that from Congress through all of the hearings with SBA, Secretary of Treasury Mnuchin during these past few months related to the SBA programs. Not only would we expect the Bureau to continue to enhance its data collection on small businesses and small business lending, but likely there could be a change in the enforcement of fair lending at the commercial level. One interesting issue was flagged a long time ago, just in 2017, in an update the Bureau issued. Never got to proposed rulemaking, but we've seen this come up with a lot of the prudential regulators. LEP borrowers continue to be a significant source of concern for regulators, limited English proficiency borrowers. And as we see this default environment start, this could be a significant concern because you're having people calling in, seeking assistance in a very customized way for their particular financial circumstances, looking to make use of forbearance modification, etc. And if that person has limited English proficiency and you don't have the ability to adapt or accommodate that, there may be some significant disconnects in their ability to obtain those services. So LEP efforts we may expect to come back onto the agenda. And then also, we mentioned the back and forth with auto lending. It's kind of the hot potato that has been passed back and forth through different CFPB administrations over the years. Everyone's trying to look at auto lending, but there's very little ability to directly oversee auto lending, and so all of it is somewhat tangential and enforced against the lenders who are providing financing indirectly to the auto sales groups. And so we would expect that to continue to be a hot button issue. With that, that's kind of where we see things moving in 2020, 2021. I know we've had some folks from the Bureau on the line here, and so would welcome if you just say, you two guys are nuts and we would never do all that. We certainly welcome that feedback. If you do have questions, comments, want to talk about any of this in additional detail to any of our participants, feel free to email either of us. We're happy to jump on a call anytime. As we say, always appreciate you participating on these In the Trenches programs. This, like all of our other, I think we're up to 18 or 20 of these In the Trenches, are posted online. YouTube has a collection of all the recordings of these presentations, and the slides are available. for your use. If you're a compliance professional, if you're looking for some hot topics you need to be looking forward to in 2020, 2021, you're welcome to make use of all these materials however you deem appropriate, because as we say, we're always here to try to make the compliance professional's job, to the extent we can, a little bit easier to keep you abreast of changes that may be coming or are already coming. With that, Craig, final thoughts?
The one thing I would add is for a takeaway here, the issues that we've reviewed here on the last 30 slides, kind of start to talk about these within your institutions with your boards, or if you're on the board or you are senior management, start to ask your compliance professionals about them, just to kind of lay the groundwork of what is coming over the next year, and kind of now is the time to prep for that and get ahead of whatever challenges are coming in fourth quarter of 2020 or throughout all of 2021. This would be the time where you start to document that in your committee meetings and what known risk indicators are out there for compliance.
So with that, thanks everybody for joining us. Feel free to reach out anytime. We'll continue next week after a little brief 4th of July break there. Next Thursday with our In the Trenches program. If you need assistance signing up for that, don't hesitate to reach out to us. We look forward to seeing you next week, and have a great afternoon.
Thanks, guys.